Hello to everybody that's tuning in, and welcome to the latest in our series of webinars exploring anti-money laundering. In today's webinar, we'll be discussing the application of risk assessment in your firm. My name is Andrew Bryant, and I'm AML Policy Associate at the SRA. And presenting with me today is Declan Brown, who's AML Regulatory Manager. To give you a bit of background, I've specialised in AML for the past 10 years, working in private practice for a number of legal firms prior to joining the SRA, and also in financial services before that. Declan has also specialised in AML over several years in the legal sector and in commercial banking. Myself and Declan have both been at the SRA for about 2 years. So to move on to today's format, myself and then Declan will present for about 20 minutes before addressing your questions in the second half of the session. Thank you for the questions you've already submitted in advance of today's webinar. Please do keep sending them over during the course of our presentation today, and myself and Declan will address your queries at the end. You can enter questions via the link in the YouTube description, and it's also possible to do so anonymously if you wish. So without further ado, we'll make a start on our presentation. So the AML landscape. The money laundering legislation is in place to prevent the laundering of money and terrorist financing. Obviously, there's a human cost behind money laundering, such as drug trafficking, people trafficking for enslavement, or stealing public money that should have been used to develop communities. Where the laundering of criminal cash is facilitated, a criminal enterprise continues. So we've got a duty to supervise firms to ensure they're complying with the money laundering legislation. Our approach is one of engagement, where we're communicating with firms to assist in bringing them back into compliance. There are cases involving serious breaches of the regulations that require enforcement action too, but those are in a minority, and we're continuing to publish guidance to assist firms in scope to figure out what exactly they should be doing to comply. So our supervisory activities are overseen by the Office for Professional Body Anti-Money Laundering Supervision, or OPBAS, who regularly evaluate our efforts. We work to ensure that our activities are in line with their source book, which was published in 2018. The most recent significant overhaul of the money laundering regulations came about in 2017, requiring elements such as firm-wide risk assessments, which we'll have heard of, specific policies, controls and procedures to mitigate and manage effectively money laundering risk, and other training requirements as well in line with Regulation 24. So there have been several amendments to the 2017 regs after they were enacted. Many of you will be aware of a recent amendment too, which adjusts the list of high-risk third countries in Schedule 3ZA, for example. Do have a look at that and factor it into your policies, controls and procedures where necessary. Okay, so to move on to risk assessments a bit more specifically, the regs say that under Regulation 17, we at the SRA should pay attention to the National Risk Assessment from the Home Office. The NRA sets out the key money laundering risks and terrorist financing risks in the UK. The NRA has a section specific to our sector, focusing on risks around conveyancing, trust company service providers, and the use of the client account. But on the subject of risk assessment specifically, we published our last sectoral risk assessment earlier this year, which draws attention to risks around TCSBs, third-party payments, conveyancing, and many others as key areas of risk in the sector. This is in line with our obligations as supervisor under Regulation 17. As you all know by now, each firm must have a Regulation 18 risk assessment in place, which is customised to your practice. This must take into account our sectoral risk assessment. And this should also obviously assess risks around clients, transactions, services you offer, the jurisdictions you operate in, and the delivery channels as well. A firm's overarching Regulation 18 risk assessment should then flow down into the risk weighting and client and matter risk assessments, which are conducted on a case-by-case basis within a firm. Excuse me, and I'll come on to that in a moment. So at the core of case risk, specifics is Regulation 28 of the MLRs, which says that the extent of CDD, customer due diligence, depends on what was in the firm-wide Regulation 18 risk assessment and the risk arising in the particular case. So that second part means the risk arising in the specific single matter that's being worked on at that point in time. This gives rise to the client matter risk assessment. This is further reinforced in Regulation 2812B, which says the ways in which a relevant person complies with the customer due diligence requirement may differ from case to case. So what must go in it? So based on our publications and your own firm-wide risk assessment, on a matter-by-matter basis, consider risks to do with your client, geography, products, transactions, and the delivery channel of the specific service. This should then inform the extent of the due diligence that you undertake. So much of this concerns who your client is, how they are controlled, where their money comes from, the sort of work you're doing for them, and its monetary value. Also important is the delivery channel of the matter. I appreciate, some people have difficulty, understanding what this might mean in our context. For example, it could mean the work, if the work's being conducted remotely, where you will never see the client, or if the client's communicating with you via an agent. In terms of what this looks like in real life, we don't expect a matter risk assessment document to be lengthy. In some cases, it could be as little as a few lines of text. The risk assessment could take the form of a file note marked risk assessment that acknowledges the factors on screen and considers the wider risk factors your firm is exposed to that are explored in your firm-wide risk assessment. You could also assign an ongoing monitoring review period also, so you can revisit and refresh the client-specific customer due diligence at an appropriate time that you define. For larger firms, it might be more appropriate to have a digital risk assessment template built into a case management process that's got a factorial scoring of risk, which kicks out a risk score that's tied to a certain level of due diligence and a defined ongoing monitoring review period. Pardon me. Again, the level of risk tied to each type of client's country, product, etc., should be informed of your firm-wide risk assessment because it explores the unique risks that your firm is exposed to through the work that your firm carries out. So further on what must go into it, something specific to the matter risk that are called out in the regulations that must be considered in the matter risk assessment are the purpose of the transaction. What is it for, who actually benefits from the transaction and why, and you must write down why you think this makes sense. The size of the money or assets also, think, is it atypical for the client? Do you know that they've got that kind of money? Also, timing of the business relationship. Is this the first you've heard from the customer? Is this a repeat transaction for the same kind of work? And have you known the customer for a while? So tied to these facts, you should be thinking about what you know about your relationship with the client. Is this a standard repeat transaction or something more out of the ordinary? So when should you do it? When should you do your matter risk assessment? So your matter risk assessment should be recorded at matter inception for every matter for every client. It's important that the assessment of risk is recorded so that others involved in the client relationship can access it, and also so it can be amended and, if necessary, as part of your ongoing monitoring obligations under Regulation 28 as the matter progresses. For example, the funding source for a transaction could change, or there could be a change to ownership or control of a client corporate. Examples like this would often require an adjustment of risk rating and the gathering of further due diligence. Within your paper files, systems or processes, the risk assessment should be accessible to all so that they can review it as they need to if they are dealing with a client or undertaking a process such as a file audit, for example. Okay, so now I'm going to hand over to Declan, who's going to give further insight on client matter risk assessments and also share some observations from our proactive team's firm AML visits. So over to you now, Declan.
Thanks, Andrew. So Andrew's already touched upon this slightly, but there are 3 key provisions that I really want to draw your attention to again. And these are Regulation 2812, Regulation 2813, and Regulation 33.6. Now, Regulations 2812 and 2813 are clear. You must record a risk assessment as part of your CDD. And this is at both client and matter level, although there might be a slight crossover between both. Now, Regulation 33 talks about the obligation to apply enhanced due diligence, or EDD. And EDD is where you scrutinise a potential business relationship or matters in greater detail. And it's designed to make you take further measures where certain risk factors are present. Now, there are certain situations where EDD must be applied. For example, where politically exposed persons or PEPs are involved, or if there are links to high-risk third countries, or where transactions are complex or unusually large. Now, you must also consider whether there are any other factors which may potentially make your client or matter high risk, and many of these are outlined in the Regulation 33.6. Now, if you were to identify one or potentially more of these factors to be present within your client or within the matter, it doesn't automatically mean that that client or that matter is high risk. If, however, you decide that the matter isn't high risk, you must document and record your rationale as to the reasons why you've made that decision. Likewise, there may be other factors that aren't outlined in Regulation 33.6, but are present within your client or matter, which you may think, actually, this makes my client or my matter higher risk. I think the key requirement, what we're trying to get at here, is that you and your fee earners must make an assessment as to the level of risk with your client and your matter. And that will inform your approach into the types of CDD documents that you can gather to help you mitigate the risks. So the next slide here just touches upon some of the stuff that we've been doing as part of our proactive work and some of the stuff that we've been seeing. And some of these findings you may already be aware of. But just to recap, from September 2019 to October 2020, we visited 74 firms to review their AML policies and procedures and see how these were being applied on a sample of their files. And this produced some quite interesting findings. So you can see the first one that we've got up there, on 29% of the files that we reviewed, they did not contain a client or matter risk assessment, which means that firms may have been unaware of high-risk clients or high-risk matters that were passing through their hands. There were also occasions where a client or matter risk assessment hadn't been carried out because the client was a personal friend of the fee earner or a personal friend of a partner at the firm. Now, while this factor may be relevant to the overall risk level, it's not in itself a reason to not carry out a client or matter risk assessment. Closely linked to this, on sort of various files that we reviewed, an analysis had been carried out, but there was no conclusion as to the file's overall level of risk. For example, if it was high risk, medium risk, or low risk. And again, that makes it difficult for the firm to know if enhanced due diligence should have been carried out. We're also seeing occasions where fee owners were incorrectly assuming that e-verification was a risk assessment. Now, the information which is obviously collated by e-verification tools is certainly very useful to your overall level, to your overall assessment of the level of risk with your client or matter. However, we're of the opinion that the search in itself would not constitute an appropriate risk assessment as required under Regulation 28.12 and Regulation 28.13. And this is because it doesn't really provide any real assessment as to how that information which has been gathered, how it applies in the context of your firm or context of your client or in the context of your matter. We also found on occasions where matters had been risk assessed, there was conflicting information between the matter risk assessment and that in the firm-wide AML risk assessment. So for one firm, for example, set out in their firm-wide risk assessment that all conveyancing matters should be high risk and EDD should be carried out. And when we reviewed a sample of files for that particular firm, conveyancing files, they were both assessed to be low risk and EDD hadn't been carried out. Now, your client and matter risk assessments must reflect your firm-wide risk assessment. And what we suggest is that those who are responsible for assessing client and matter risk should have access to your firm-wide risk assessment and should be encouraged to consult it. So the next slide here just touches upon some stuff that we consider to be good practice. And again, some of this has come out of our proactive work that we've seen on the ground. So first and foremost is making sure that the risk assessments that you carry out on clients and matters are recorded. And this will help you and anyone else who's working on the matter identify any areas where caution should be exercised. The better you know your clients and the better you understand your instructions, the better place you'll be to assess the risks, spot suspicious activity, and help protect your practice. Another example of good practice that we're seeing is fee owners setting out on the client or matter risk assessment forms that you're using different factors that the fee owners must consider. Now, there is a slight caveat here in that we don't want to encourage a tick box approach whereby fee owners are rushing to complete the assessment and are not paying any consideration to any of the factors which have been identified on the form. That said, we accept and we appreciate that there's a lot to consider when it comes to AML compliance. So what I would suggest and what I would encourage is that people really take their time when considering the factors that Andrew was discussing earlier. I'd also suggest that the form includes a free format summary box, which encourages fee owners to record their rationale around their overall risk rating. It's also good practice to review the risk assessment at certain milestones, for example, at the midpoint of the matter or prior to the transaction completing. And this will ensure that your knowledge of the client or knowledge of the matter remains the same, or whether there are any new risks that are now involved which have not previously been identified. And it will also help you meet your ongoing monitoring obligations as outlined in the Regulation 2811. And the last point that I've got up there is another area which came out of our visits where firms do appear to be struggling, and that is with carrying out an independent audit. Now, I won't go into this in too much detail, but under the Regulation 21(1)(c), dependent on the size and nature of your firm, you should consider carrying out an independent audit to examine the effectiveness of your AML controls and procedures. Now, by carrying out an independent audit, you'll be able to see how effective your client and matter risk assessments are. You'll also be able to check that they're actually being used in practice. Now, I should highlight that for the purpose of the regulations, independent does not necessarily mean someone outside of the firm. They can be based within your firm, but they just need to be detached from your AML processes. So the next slide here just touches upon some stuff that we consider to be bad practice. And again, some of this has come out of the work that we've been doing with firms. So first and foremost is not documenting clients or matter risk assessments. Now, while there's no prescribed approach as to how you record your risk assessment, they must be written down so that there can be evidence. And you must make sure that all relevant risk factors have been considered and any decision making or rationale is recorded as to the overall level of risk. The assessment should be signed either manually or digitally by the person who's carried it out and dated, so you know when it was done. And we do take it seriously where clients or matters haven't been risk assessed. You know, ultimately, if you don't know the risks which are present on your file, you can't mitigate them. So the second point that I've got up here is around fairness not having sight of client or matter risk assessments. And again, this is a recurring theme which came out of our visits, where fairness were unaware of the level of risk with the particular matter or the client that they were dealing with. Now, your fairness, this is probably more applicable to firms where who have centralised due diligence teams or where CDD is carried out by support staff. Now, while there's nothing wrong with taking this approach, you know, your fairness must have oversight of any CDD which is gathered, which includes client or matter risk assessments. So the CDD must be reviewed by the fairness so that they're aware of any risks which is present on the file or with the client that they're dealing with. Ultimately, your fairness, the ones who are handling the matter, are your firm's first line of defence. The best place to spot any changes in the client's behaviour or to the funding or to suspicious activity in general. And the final point that I've got up there is around ensuring that the documents or the method that you use to risk assess clients or matters, looks at risk assesses the AML risks adequately. Again, we have on occasions come across risk assessments on files which look to be assessing business risks as a whole, for example, making sure that the client has the ability to pay the fees. Now, while there's no harm in considering other risks, ultimately this document should be used to inform your approach as to the types of CDD documents that you should be gathering to help you mitigate any AML risks. So it must be adequate. So the next slide, or the next part of the webinar, we're going to be discussing some of the questions that have been pre-submitted through to us. So thank you in advance to those of you who have submitted questions to us. Please feel free to submit any more that you have through the function online there. Andrew, I'll start off with the first question that we've got. So what areas or types of work would you consider to be low risk?
Thanks very much, Declan. Sorry. Thanks very much, Declan. So that's, a broader question, but I suppose that, a low value piece of transactional work that falls into the scope of the regulations could be considered lower risk. But, in terms of clients, the traditional regulations view is that client corporates that have already gone through a degree of AML oversight via a financial regulator or stock exchange could be considered lower risk also. But, these are facts in isolation, and the different areas of risk, such as geography, delivery channel, purpose of transaction, etc., should be considered in the round before drawing risk conclusions. So, when you're working with a client, you should be alive to the full kind of list of facts at hand, really, before drawing risk conclusions. So I hope that helps. Okay, I'll look at the next pre-submitted ones now. One we've had says, is it necessary to risk assess each new matter for an existing client? Declan.
So that's an interesting question, and it's not quite as clear-cut as a simple yes or no answer. So obviously we're discussing this in the context of repeat clients. So there may be occasions where you do not need to complete matter risk assessments for repeat clients where work is highly repetitive and the risks remain the same or consistent across the work that you're doing for these particular clients. I think the purpose of this webinar, what we really want people to take away, is that the purpose of risk assessments, clients and matter risk assessments, is to demonstrate and evidence that you've taken a risk-based approach and that you've applied that risk-based approach and that you've considered the factors under Regulation 2812 and Regulations 2813. If you're aware that work is going to be highly repetitive for a particular client, and you know the risks are going to remain consistent, that needs to be recorded somewhere. Now, so sort of circling back to the original question, should some form of assessment be carried out? The short answer is yes. But that can be as simple as, it can be as short as, does this work still fit with what I know about the client? Is it in line with their usual instructions? Does the funding remain the same? Essentially, you're looking to identify any areas that fall outside of what, out of the ordinary with your clients and identify any sort of new risks which you then need to mitigate. And if you do take this approach for clients where work is sort of highly repetitive, you do need to make sure that obviously you periodically review your CDD, and the time frame for which you do that will be dependent on the level of risk, and that will be down to you to decide as part of your risk-based approach. Similarly, if you've got linked clients or who are part of the same transaction or part of the same matter, you may choose to use the same matter risk assessment form. What I would suggest is that if we were to come and visit and we were to pick that particular matter to have a look at and see what checks are being done, we would expect to see some form of assessment carried out on that matter somewhere. So it's down to you to sort of where you record that and how you record it. So I'll move on to another question here. So if the client is low risk, but the matter is high risk, what steps can or should we take?
Thanks, Declan. So, I suppose to start with, you should be thinking, why is your client doing a high risk matter where they might not have before? And, is it consistent with their business and what you know of them? The matter risk assessment should document your risk conclusions after considering the client and the piece of work. The key here is for you to do due diligence to a reasonable extent until you're comfortable, and to write down why you are comfortable with the client and transaction. We don't want to encourage a gold-plated approach of gathering reams of documentation where it isn't necessary. The key is really, that you must work on the basis of being comfortable to do so. Okay. So I think we have another pre-submitted one here for you, Declan, which is, what format should a risk assessment take?
Again, this is an interesting question, and I know you touched upon it in in the webinar just then, but there is no prescribed format as to what it should take. It just must be documented and written down so it can be evidenced. From sort of the work that we've been doing, we've seen some really interesting approaches. Some firms have created their own sort of template risk assessment form that they complete. Some firms have really sophisticated sort of software where the risk assessment is built into their case management system, so the fee earners can complete it there. We've also seen some firms that quite simply just, like you say, make a file note, and set out the reasons as to why, what they've considered and why they consider it to be low risk, and just make sure that that's saved on the file so that it can be identified. So in answer to the question, there is no prescribed format. It just needs to be written down so it shows that you have considered the risks and documents what steps you've taken.
Agreed.
So thanks to those that are submitting the questions as the webinar's going on. So we've had a few questions around independent audit, actually. So we've got here question on the independent audit. The independent audit function, the independent audit Reg 21(1)(c), is this mandatory for all firms? For example, would a personal injury firm need this? Andrew, do you want to take that one?
Yeah, I'll at least make a start in it. So, a personal injury firm that does not do a work that's in scope of the regulations wouldn't necessarily need to conduct an independent audit, because they're not in scope of the regulations where this is a requirement. And it might not be necessarily mandatory for all firms. It depends on the size and nature of your firm, or whether you think one's appropriate. And within the regulations, there is a separate provision to review the policies, controls, and procedures, and to mark the result of that review somewhere. Make a record of it. But yeah, independent audit isn't mandatory for all firms. Did you want to add anything to that one, Declan?
Yeah, I was going to say, I mean, I guess it's down to sort of decide on the size and nature, isn't it? The regulations are quite clear. It says, dependent on the size and nature. So when you're considering the size and nature, you need to be thinking about things sort of, how much work do I do falls within scope of the regulations? How much of this is high risk? What types of sort of transaction volumes am I dealing with? It's all about taking that risk-based approach, really, and deciding, is this going to be necessary? Is it going to be sort of relevant for me? Again, that's down to firms to make a decision. What I would suggest is obviously, as I touched upon in our webinar, sorry, my slides just, it doesn't need to necessarily be someone outside your firm. It can be someone within the firm, but they just need to be detached from your AML policies and processes so that they can look at it independently and give sort of valuable feedback on that. You'll also need to make sure that the person who carries out the audit has is at a level where actually any changes that they do recommend are taken forward and they are acted upon.
Okay, cool. I will select another question for you now. I think we've sort of addressed this one already, but a question from John. If we have repeat clients who routinely do the same work, do we really need to undertake a new matter risk assessment each and every time?
And again, I think going back to sort of what I said earlier, just that will be that if you do have sort of clients where the work is highly repetitive, and the matters, the risk across the matters that you're doing remains the same, there may be occasions where you don't need to do a new risk assessment each new time. But as I said, if we were to come and visit, we would expect to see some form of assessment carried out somewhere for that matter. So if the work is going to be highly repetitive for one particular client, you may wish to document that somewhere, so at least it can be referred to. Again, the idea of the risk assessments is to identify if there are any new risks which are present, which where the risks then need to be mitigated. You can gather the appropriate CDD.
Okay, great stuff. Do you want to fire one at me now, Declan?
Yeah, sure. So I've got one here. So how would the SRA treat a lack of risk assessments if you found one during an inspection?
That's a very interesting question. So, I mean, from our point of view, we would be taking a look into the policies, controls, and procedures of a firm, of which kind of risk assessment is a constituent part. And so, if there aren't any in place, that may be indicative of wider failings, across kind of the firm-wide risk assessment policies, controls, and procedures into, what's happening on the desks of fee earners. So, that fact taken in isolation, it might not necessarily lead to anything kind of, on the enforcement side, but it's something that we take seriously, and then would probably lead to kind of further analysis on our part to see what's really going on under the bonnet. Okay, I hope that helps. Okay, so another question that we have had from Rachel. She says, should non-face-to-face clients always be treated as high risk?
This is a good question, and I think non-face-to-face clients, the outlines under Regulation 33 about sort of non-face-to-face being higher risk. So I think you do need to sort of treat them with a degree of more risk, and you do need to sort of perform additional checks. That said, obviously, the world has been changing, obviously, particularly over the last year when sort of with the pandemic. So remote clients are becoming more the norm, but I think the risk certainly increases where there is that non-face-to-face element, so you should sort of be applying additional checks to sort of mitigate them risks.
Very good. Okay, would you like to select one for me, Deck?
Yeah, sure. So if an electronic risk identifies a client as a possible PEP, and we send a form to the client asking all the right questions, which come back with a no to all questions, so a client is saying not a PEP. One, what assessment would you apply to the client at this stage, low, medium, or high? And two, can you rely on the client's answers, or should further steps be taken?
That's a very good question indeed, isn't it? I mean, it would depend on what kind of, first of all, when you've done your electronic check, what level of information they give you about that person. Do they give you their likeness and their date of birth, and is that consistent with what you've been given? And because if they're declaring by return that they're definitely not that person, and then all the evidence you've got indicates that they are in fact that person, then you may wish to question your carrying on with that particular client. And that's be the question: what assessment will you apply to the client at this stage? So yeah, I mean, taking everything else in the round, it would depend basically on all the other risk factors. What risk level you assign to that client, and as I say, if you think they're actually being dishonest, you might not want to continue at all. But of course, you're free to ask reasonable questions of your client to kind of figure out who they are and where they come from or where their money's come from, and then form a risk assessment on that basis.
I think I agree with that. I think it's about taking that risk-based approach as well. As you say, if you've got no reason to doubt what the client's saying, then I think you should be able to take their word. But I think, yeah, absolutely, you need to, with the information that's been gathered by the electronic risk, it's about establishing sort of, how much that matches. If you do have a potential date of birth match, you might want to look into it a bit further.
Agreed. Okay. I've got a question here that says, if a high percentage of a firm's residential conveyancing clients are high value, should they all be classed as high risk, i.e. can something which is high risk for other firms be low/medium risk for a firm which deals with this type of transaction regularly? And in brackets it says, with only matters where other risk factors apply, such as geographical connection being classed as high risk.
I think that's a really good question, and this is where sort of this is where you need to decide on your firm-wide risk assessment, and this is where the importance of a firm-wide risk assessment really comes in. So first of all, can something that's high risk for one firm be low risk for a firm which regularly deals with that type of transaction? Yes, that potentially could happen, but it's about establishing why is that lower risk for your firm? Is that because your fee earners have the knowledge and the expertise to deal with it? Is it because you've got the appropriate controls in place to deal with the risks? So if you do make that decision, so if you sort of do make the decision that actually, we consider something to be lower or medium risk, you need to document the reasons why in your firm-wide risk assessment, to explain, what reasons you consider it to be lower risk. So yeah, I think that's, you just need to make sure that in your firm-wide risk assessment, you obviously assess the risks and you document the reasons why it's a low risk. And yes, you make a decision from there.
Thanks very much, Dick. Okay, I've had, I think just one more question there, which says, do you think that verification should be undertaken pre or post the risk assessment? It's a bit of a $1 million question, that one. What's your view on that one, Dick?
So for me, I think it should be done pre doing the risk assessment. The reason being is because you might have potential, depending on which e-verification provider that you're using, you might have a potential PEP match, you might have a potential sanctions match, or you might have something that comes up which potentially says that the client doesn't actually live at that address. So personally, I think it should be done pre-risk assessment, just so you can help you to identify the risks which are present, and then if there are any that come up on there, you can then potentially mitigate them risks by asking additional questions or seeking additional evidence. Do you have any comments on that, Andrew?
Yeah, I would agree with you there. Because basically, when you do that e-verification, it's going to present extra facts to you that could be pivotal in doing your risk assessment on that particular client and matter. So it is worth doing it, first of all, if possible. I would agree with you there. Okay, I can't see any more questions coming through. So thanks to everybody that submitted questions. I hope our response has helped. But I just want to bring up one last slide before we close off now. Currently, our business plan and the practicing certificate fee consultation is out there at sra.org.uk/consultations. Do have a look at that, and we're keen to hear your responses The consultation is open till the 25th of June, so please do have a look at that and come back to us. But I think all that's left to say is, we hope you found our session today useful and found some helpful information in it. Look out for upcoming presentations by the AML team in the coming weeks and months, because there'll be many coming out. But yeah, thank you very much for your participation today, and have a good day. Thank you, everybody.